Welcome to this edition of Real World Employment Law, where we discuss real-world issues impacting businesses and executives. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard, and I also head up the firm's employment law practice.
And I'm Drew Smith. I'm a senior associate here at Berenzweig Leonard, and I also do employment law matters.
Drew, thanks for joining me today. This better be good. I put on a sport coat for this, so I hope you've got some good stuff that we're going to be talking about here today.
Well, hopefully we can help our clients and some other individuals out there better understand what this whole EEOC process is.
Yeah, let's talk about it. So today we're talking about the EEOC process. First off, people hate acronyms, but we're in D.C., so they're pretty much part of the everyday lexicon. But Equal Employment Opportunity Commission, what is that?
So that is the commission. It's a federal agency that oversees claims of discrimination. And so before you are permitted as an individual to go and to have a claim of discrimination before a court, you actually have to go through an administrative process first. And that is either going to be through the EEOC or some type of a state or local equivalent.
So, Drew, I grew up watching legal shows. I'm going to date myself here because Boston Legal with the great William Shatner, right?
I thought you were going to say Perry Mason.
No. Ally McBeal's the other one. And so in those shows, here's the problem with those shows. They always, a case would come in the morning, and by the afternoon, they're arguing in front of a judge. But in real life, that's not really what happens with these discrimination cases, is it?
No, I mean, you're going to get a charge of discrimination, and it could take, I mean, literally, it could take years for it to be investigated, to get through to the point where there's a right to sue letter, or alternatively, perhaps the EEOC decides to take the matter on themselves and serves to litigate it.
Okay, so let's talk about the process. So a company receives, sometimes in the mail or sometimes it's by email or something, they receive what's called a charge of discrimination. What is that document?
So that document, that's the first document that an employer is going to get. And what it does is it's supposed to set out the basis for the discrimination. And so it will say who the person is, it will say who the company is, and then it will give a kind of a short narrative as to what the claim of discrimination is. There's also going to be some check boxes that are going to say, you know, if this is a discrimination case, if this is retaliation, and what is the basis of it? Is it age? Is it gender? Is it a disability? And then from there, you should have a good understanding of what is being alleged against you.
Well, you say that, but I'm just going to tell you in real life. I mean, these charge of discriminations, and you and I know this. Yeah, you're right. Okay, so it's a form, and it's got a little bit of a box at the bottom for a narrative. I've read some of these charges of discrimination, and I scratch my head and I say, I don't even know what this is even about. So it's fair to say sometimes these things are pretty sparse, aren't they?
They are sparse. Now, that also can help you later down the line because that actually locks in the complainant. They cannot mark, for example, if they say, well, this is a retaliation case, and then moving forward they try to alter it and say, well, this is discrimination. You can't do that. So you're kind of locked in to what you're claiming within that narrative. So for an employer, it is advantageous to be perhaps a little bit more imprecise with the facts.
Got it. So you literally, the complaining employee literally checks boxes. So was it gender discrimination? Was it race discrimination? And if they don't check the box, fast forward, a year or two later and you're in litigation, that form becomes pretty important. If they have not checked all those boxes, they're limited, right, unto what was on that form.
Yep, and we actually just recently litigated a case where that became kind of a point of contention, and
How'd you do on that one?
We won on a motion for summary judgment.
This guy's got a winning percentage on these EEOC charges. He really does a good job for our clients. Okay, so the charge comes in and the company gets it, and I think they have 30 days to provide a position statement, which is kind of their rebuttal. But tell me about that process of doing a position statement.
Sure. So first, when that initial letter comes in, the charge of discrimination should be attached. You want to make sure that you read it because there sometimes are some supplemental documents that will request additional information. We've got a client who recently received one that there was 2 categories of documents that the investigator specifically wanted. So you want to make sure that you're responding. You also need to find out how to respond. There's a respondent portal through the EEOC that now the EEOC wants you to upload everything through. Some of the local and the state agencies don't have that, so you have to respond directly to the investigator.
And just to stop you there, the process is important because, a company gets one of these charges and, their defense mechanism is up pretty high, and sometimes they're not happy that these allegations are being made. I mean,
Sure.
not always, but sometimes they're not happy that they're made. And there's a maybe an inclination to thumb your nose at the process and say, kind of like, why do I have to go through this? But you're saying, treat it seriously. Why do they need to? Why can't they just say, you know what, this is the administrative phase. This ain't court. Why do I really care at this stage?
Well, like we were talking about before, the administrative stage locks you into your position, and that's not just from the employee standpoint, it's the employer's. So in your rebuttal as an employer, if you are including information that's inconsistent, maybe it's even vague, that could come back to bite you if it ever does move into the litigation phase, because you're going to be bound by what you have within the position statement. And if you start to waver from that, just like an employee is going to get kind of knocked down, an employer is going to get knocked down if they're inconsistent. And if you're inconsistent, there is a presumption that discrimination exists.
So an example of that would be, you get this charge of discrimination, you don't run it through perhaps the HR channels, you don't go to outside counsel that maybe you have on board for most of these cases. And so you just write back and you say, you know what, this employee was a horrible performer, and that's why we terminated this employee, because they messed up a bunch of their projects and deliverables. They send that in as a position statement, and later on they get sued and they say, you know what, that wasn't the real reason. It was because they were excessively tardy every day.
Right.
That's a situation that's not good. Why? I mean, why can't an employer change its mind, maybe look into it a little bit more?
Right, because that presumption is going to be that now that you have an inconsistent position, that you have discriminated. You're looking at some type, it could be pretext.
Okay, so that's
discrimination took place.
So that's critical. So you really want a very centralized process of handling these claims. You shouldn't just say, okay, when it's in the administrative phase, that'll be the direct manager gets to respond. It really should be a combination of the manager, human resources, and frankly, legal counsel, just so that, because if it does turn into litigation, legal counsel is going to be involved anyways. Make sure there's consistency. So that's a great point. When you go about doing one of these position statements, what's your kind of approach to it?
Well, let's go back. I mean, the best thing that employers can do is to have sound policy, to have employee handbooks that have policies included within them, but documentation.
But when you say, first for the handbook, when you
Yes.
say policies, you mean the Equal Employment Opportunity Policy, the EEO policy. We're not going to discriminate. Sometimes companies think, you know what, why do I have to put that in writing? It's obvious that I'm not running a business to discriminate. But we see in these cases with the EEOC, when there's a claim, those become pretty important.
I mean, it shows that you have an organization that is organized. You have some checks and balances. You have some wherewithal about you. And that's the same thing with documentation. When we have a client that comes in and there's a charge of discrimination and they say, oh, we didn't do this, we didn't do this. That's great. Show us. Show us, what have you done? Well, this person was a poor performer. Show us how they were a poor performer. Show us.
And how many times have we asked for that documentation? We get the review, the annual review back, and it's good, and it's glowing, and it's like, well, we didn't want to rub salt in the wounds, and you're like, okay, but now we're kind of stuck with the written word at the EEOC stage. So that's a great point. Yeah.
Or alternatively, you have someone that well, they were in trouble. They were constantly late. They were this. Okay, well, where is the written documentation of this? Did you ever? Well, we just spoke with them. We didn't actually write anything down. It's the clients who come in organized, that have written documentation that say, hey, look, here is their first written reprimand that they had for this. That's powerful within a position statement, because a position statement should be centrally focused. You don't want to throw the kitchen sink at an investigator, but it needs to be supported and supported through documentation. And so that's something, employers should be having those types of practices now to prevent, future issues.
Yeah, and to be fair, listen, companies are in the business of making money. They're in the business of employing people. They're in the business of delivering goods and services. So they're not always in the business of like having beautiful, policies and everything.
As much as we would like them to.
Yeah. So the one thing I tell companies are, look, I don't care if it's wrapped in a bow and it says written counseling record and final warning and stuff. Find me emails, because that's how people, communicate mostly at work, although now it's through all kinds of Slack and everything like that. Find me communications where I can objectively say this employee was on notice of poor performance.
Absolutely, and we actually have a case that just came in about 2 weeks ago where that is the case, where it's not a lot of typical HR type of documentation, but it's a lot of emails where they were sending the employee emails saying, you're just not living up to expectations. You're supposed to be doing this. This is part of your job duty. You are not doing this. We're asking you to do this. Great, that shows insubordination. It shows that they were not performing, and that is also helpful.
Yeah, EEOC loves that stuff. They love that it's in writing. They don't care as much of what form it comes in. What they're most concerned about is that it's contemporaneous when it was going on.
That's right.
Not now when you get the charge of discrimination and you are now saying they were a horrible performer.
Right.
And I remember in my memory all these things that they did. It ain't going to cut it. Okay, so you got documentation. What about other employees, managers, coworkers? How do those come into play in these?
Well, it depends. I mean, sometimes we want to talk with the witnesses to this and get their take and see what how things played out. Occasionally, my feeling is that if there is not a lot of documentation, that witness statements can be very powerful and can be woven into the position statement itself, and that can kind of help to reinforce the defenses that the employer is trying to give.
You and I, on the witness statement aspect, you and I talk a lot about the best strategy, and you have to be flexible in terms of how you approach it. But a witness statement can be both take many forms. It can be a witness statement where it's just their write-up of stuff, or it can be an affidavit, and an affidavit is something that's sworn to under oath, under penalties of perjury. My personal concern is if I'm just getting involved in a case, I recognize that the witness is most likely telling the truth, but I don't know all of the facts yet. And so I'm a little bit wary of doing that full-blown affidavit right from the get-go. But there may be situations, do you think, where that's appropriate?
Yeah, I think I've had situations before where it's been appropriate, and honestly, it's been needed. Situations that I'm thinking of right now, it was where there was kind of a paramount event. There was some type of singular event that took place which forced the termination of an employee. I'm thinking about a position statement that we wrote probably about 2 years ago where the employee stood up and threatened people during a meeting, and there was not documentation of that. However, having witness statements come up and they sign an affidavit that basically says, I was here in this meeting, this is what that person said. And when you have 3 or 4 of those, it's hard to refute that you didn't do these things. So that's a situation where I find affidavits to be extremely helpful.
So you hear the phrase a lot, less is more. And even just talking to other employment lawyers sometimes, they'll say, you know what, the less you say at this early stage, the better. How does that jive with your approach?
Well, I've never been an investigator for the EEOC or any of the state local equivalents, but my take is you want to be thorough and you want to have a story that makes sense and that's easy to follow. And you want to include facts to show here is how things played out. And here, when you're scant on detail, in my opinion, it makes it seem like you're hiding something, like you're kind of bouncing around, but you're not really getting into kind of the shadowy part of it. And my take is you want to include details that are relevant to the situation, that are focused, but you want to be thorough in those facts.
Yeah, I think it's a great point. And I think the reason why you want to be thorough is you got to recognize who your audience is. Your audience is not just, so when you submit your position statement, you upload it to the EEOC portal, but that is not just going to stay with the EEOC investigator because they have changed their policies. They now will give a copy of your position statement to the charging party, the employee who's making the complaint, and by extension, if there's an attorney involved on the employee side, they'll also be able to see that because they're just representative of the employee. And so you're writing it also for them to say, listen, we feel very confident. If you write a very sparse position statement, it's going to be like, wow, they're hiding something. Just as you said, they're hiding something. But if you write a really thorough one, backed up with facts and documentation, the employee is going to be like, man, they actually have the ducks in a row. And the attorney is probably going to look at this and say, man, did I hitch my ride to a winner or perhaps not? So that's another concern.
Yeah, and that's a good point because that was not always the case where the position statement would be shared with the other side. And knowing that no matter what happens at the end of this process, that they are the complainant is going to get the opportunity to take this to court if they so choose, you want to really send a message as to here are the facts that we have. Here we are adamant about this. Here's the documentation and everything else that we have. You do want to kind of assert yourself.
Yeah, we're not rolling over on this claim, so don't think that this is going to be a quick settlement. The other nuance maybe we should just quickly talk about is they do provide the charging party with a copy of the position statement, but they don't provide the charging party attachments that are deemed or designated as confidential. And I don't think a company can overdo it, but they can protect sensitive business financial information, sensitive other business information, things like social security numbers, sensitive medical information that could be relevant in an ADA, Americans with Disabilities Act, disability discrimination claim. So employers need to know that the form of the position statement is critical too. Put what you want to turn over in the position statement, but if you want stuff to stay just with the investigator, put that in a confidentially designated attachment.
And I've even had opportunities, that case that I was actually talking to you about before, where there were some threats that were made during a meeting. I had witnesses who were more than happy to speak with the investigator, but did not want their names and contact information to be given to the other side for obvious reasons. So we asked, and we were given permission to redact the names of those individuals within the position statement itself.
Yeah.
And so, there is now this new confidential requirement that you have to abide by, but it changes the ballgame a bit when you know that the other side is going to at least get a copy and able to read what you're writing.
Okay, so you get the position statement in, you upload it to the portal, and what happens next?
Well, that's a good question, because sometimes it can sit, in front of the investigator
for a long time.
Sometimes, I mean, we've had situations, and recent situations where we know there's a backlog with the EEOC due to COVID and other staff shortages and the like.
Yeah.
But we've had some that specifically statute of limitations, because you have to file your as an employee, you have to file your charge of discrimination within 300 days of the last incident of discrimination. Otherwise, it's untimely. So we've had some before where it's untimely, and the investigator sees that, and we get something back within 2 or 3 days. There's other times that 6 months, a year, not hearing from the investigator. And we, as a firm, we make it a practice to follow up. I try to do every 90 days and just to follow up with the investigator, see where things are, see if we can be of any help. But they can sit, and once the investigator, is able to get to it, they're able to take a look. It can also go in a number of different directions.
What are some of the things that they'll do, like the investigator?
I mean, they have kind of a wide berth when it comes to what they can investigate. So they might ask for witness statements. They might ask to interview certain people.
I've had many of those, where they just interview them. Yep.
They can ask for additional documentation and say, hey, you say this in the position statement, they're saying this. Do you have any documentation which shows this? They can simply say that there is no finding, and that they're going to issue the right to sue letter, which I'm sure we'll get to, or they can have an adverse finding.
So let's talk about that. So there's really, I mean, it's not a courtroom process. So it's not like you're found liable or not liable. It's a little bit of a different administrative process. And so there's really two ways that they go on these. Mm-hmm. One is basically, we're really not seeing, we can't substantiate the findings. They never say it didn't happen, really. Right. It's mostly we can't substantiate the findings. And in that instance, they issue what's called a right to sue letter. Sometimes employees get that, and they think it's like a stamp of approval from the EEOC saying, run to the courthouse. This thing is a live wire case. Is that the case now?
No, that's not the case. And you're right. And they put it, the EEOC and the other agencies, they put it in kind of lighter language when it comes to, there are not facts to support the claims.
Yeah.
So they're not saying that, we're not saying one way or the other that
it's not you, happen. It's me. Yeah. Right. it's the EEOC equivalent of that, letting someone down easy.
That's right. But they get this letter, and they have 90 days to be able to take their claim and file it in court, and to try to litigate it. So they're able to litigate those claims within 90 days.
File it within 90 days.
You have to file it within 90 days. And there's situations that I've run into before where you have somebody on the other side who, says, well, I didn't, because it's 90 days from the date that you receive it. So it might be
It's always
marked,
an issue, yeah.
Let's just say it's marked, January 1st of 2022.
Yeah.
You go, okay, well, we've got 90 days. But let's say they didn't receive it until January 15th.
We got snail mail going on with U.S. Postal Service, yep.
Right, or gets lost in the mail or something, and you have a complainant who says, "Well, I didn't get it." I've had situations where 6 months later, they say, "Well, we're gonna let this go forward because the complainant is saying that they didn't receive it until this day. We can't prove otherwise." But it's supposed to be 90 days. It's supposed to be filed. At that point, then you're in.
Then you're in litigation, and that's a whole different animal for another podcast.
Right.
So let's just say, okay, so that's where they find they really couldn't substantiate the claims. What's the winning one? What's the one where it's a little bit better? Let's say for the employee.
Well, winning for who? You say for the
employee.
For the employee. So that's where there is an adverse finding against the employer.
Okay. So they basically have substantiated the claims. Does that mean that the employer is now liable and it's just like a court case?
No. So what that means is that the EEOC can, well, again, the employee always has the opportunity to be able to take their case and to litigate it. But this gives the EEOC the opportunity to actually take the case for the complainant.
Ah, got it. And you see sometimes they do that. Usually it's the most high-profile ones.
I haven't seen it, but yes.
Yes. Well, that's because you've never lost one. But yeah, you see that sometimes where the EEOC, and sometimes it depends on what presidential administration is in power,
Yep.
What are their priorities, but you'll see that the EEOC will sometimes take these cases on. I mean, I don't think they take on a ton of them just because they don't have the resources to do so. And so in an instance where they decide, you know what, we're not going to take it on, we haven't been able to mediate a successful resolution, then what happens to that one?
Yeah, right. And there is the conciliation option as well, where they will try. So if there is an adverse finding, they will try to work something out. It might be, we want, how about front pay, back pay? How about giving this person a
reinstatement
job?
or something?
Right.
Yeah.
But if it advances beyond that, it could be troublesome for the employer because, right, if they take it on, these are usually some fairly serious cases, and they deal with issues which are relevant at that time.
Yeah. So it's a process that starts off with usually a single piece of paper called the charge.
Right.
That it's very easy based on that underwhelming piece of paper to sort of dismiss it. But I think as we've discussed today, it really is a process, the EEOC process, to be taken very seriously by employers. It's not incredibly onerous to go and do a thorough position statement and do any follow-up, but it really will help down the road to try to tamp these down.
Yeah, and plus, you by doing that, you also are able to collect all the documents. You're able to get the evidence. So if the right to sue letter. So even if you are successful,
you're ready. Yeah,
you're ready for that, and that has been advantageous to the few instances where we have won in terms of the position statement itself. There is a right to sue letter, and a complainant decides to take it to court. Great. We already know who our witnesses are. We already know what the issues are because the issues are supposed to be framed within that charge of discrimination. We have the evidence, so you have kind of a bit of a leg up, and when you are, if you have to litigate these matters.
Perfect. Well, listen, no pressure, but keep up that winning streak, Drew. And thanks for joining me here.
Thanks, Declan.
Thanks a lot.